All right, welcome back. This is the module on industrial designs. This is a single module, so there isn't this, nomenclature I usually use. What's an industrial design? So an industrial design is an artistic work, right? So a design, essentially a picture or blueprint for making something, right? That is basically, that has to be mass produced. And so it has to be manned for mass production. That means 50 or more items. So it has to be created for that reason and subsequently mass produced. And it's protected for a lower period, a shorter period rather. So And so what distinguishes an industrial design from a copyright? And the answer is not enough for them to be completely separate regimes, right? So usually an industrial design, right, a picture, a drawing of something that's original could be protected under copyright, right, because it's original and because it's fixated onto a physical medium, so it's no longer an idea. And under the standards that we sell under the modules and on copyright, that might be protected. And so what happens is, right, copyright law, the Copyright Act itself, it's section 64, is going to say, well, we're going to exclude, right, section 64 of the Copyright Act is going to specifically mention that if a design is meant for the mass production of an article in 50 or more units, then that is not protected under copyright law. And so even though, right, the drawing rather, would fall under both regimes, there's a specific exclusion that doesn't make it a choice. We'll see later on, right, that you can be under two other regimes. You could be under trademark law and copyright law, and that would be fine. So in some situations, the same thing can be protected under both trademark and copyright law. That's not the case for industrial designs. And so even though the thing in the first place would qualify for protection under both regimes, it's specifically excluded under the Copyright Act. So you don't have a choice. It's either you choose to seek protection under the Industrial Designs regime, which is the Industrial Designs Act, or you don't have protection at all and you're in the public domain. And as we'll see, there's a number of significant distinctions with the copyright regime, which is the only regime that we've seen so far, right? Before we move on though, section 64.3 has a bunch of exceptions. You don't have to learn them, but it has exceptions. The two main ones are going to be, right, a trademark that's on an item. And so if you have an industrial design with a trademark, we'll see later on what a trademark is. Let's assume it's a logo for now, right? Well, you've got the logo that you put on 50 or more items. Does that mean that it loses protection? The answer is no, and so there's a specific exclusion. The second one is if you're making articles as a set, then you're counting the sets, not the articles. It's not going to be 50 total, it's going to be 50 sets of whatever you're making. You'll see there's a bunch of other ones under 64.3 of the Copyright Act. And so, right, you will have to go under the Industrial Designs Act. So as I said, right, the Industrial Designs regime exists under its own act, its own regime, completely separate from copyright law, and it's your only option, right? So you have to seek protection under that act or not at all. And as we'll see, the regime is different. The first way it's different is that you have to have registration. So you'll recall that we discussed a bunch of times that that under copyright law registration is optional. So registration could be useful in proving your right in having evidence in court that people were aware that you had something that was protected, but it was not mandatory. And quite importantly, right, protection did not happen from that moment of registration, even when registered. For the Industrial Design Act, we have mandatory registration. And so what that means is that if you don't register it, it's in the public domain, right? So what's going to happen usually, right, is there's eventually going to be disclosure of this. We'll see the disclosure can be protected if you register it properly, right? But obviously, we're going to be concerned, just to backtrack a little bit, we're going to be concerned with the disclosure of the design, because again, what we're protecting is the design, right? So the blueprint for the product. So what matters under this regime is not the disclosure of the product, it's the disclosure of the design. But obviously, when you start making the product, right, people are going to know about it. And what happens if you haven't sought protection in time? Well, then it's in the public domain. The design's been disclosed, and you're in the public domain, and it's too late. Anyone can do whatever they want with it, and you don't have your commercial monopoly granted to you by the government. As we'll see, the protection period is 10 years. So again, that's much lower than what we saw under copyright law. And it's not really 10 years. It's 5 years, and then you have to avail yourself of the option to extend that for another 5 years. If you don't do it, it expires, goes into the public domain, and you don't get your second 5 years. And so at both moments, right, you have to actively do your job with the Register of Industrial Designs, otherwise you lose protection. If you don't register it in the first place, you're stuck, and if you don't ask for, continuation of registration after 5 years, you also end up in the public domain. So, what's an industrial design? Well, Section 2 of the Industrial Designs Act gives you a definition, right? And I'll read it entirely. It says a design or industrial design means a feature of shape, configuration, pattern, or ornament in any combination of these features that, that's the important part, in a finished article, so not the finished article, in a finished article, appeal to and are judged solely by the eye. Important parts here are appeal to and are judged solely by the eye. So it has to be both visible and it has to be, a differentiating factor. It has to be original. It has to be something that people would, try to buy for that reason. An element of design that differentiates your product from whatever else is in the marketplace. But again, we're talking about the design, not the product, even though oftentimes the distinction is going to be pretty hard to make. And protection under the Act, you're told, under Section 5.1, does not apply to the utilitarian characteristics of the product itself. And so that's basically an exclusion that's pretty similar to what we saw under the Copyright Act. You'll recall under the Copyright Act that we said the very first week about 20 times that ideas are not protected under the copyright regime. Works are. So it has to be fixated, it has to be onto something, and that something is protected under copyright law, not the idea itself that you're expressing there. And the broader reason for that might very well be that we don't want to have monopoly on thoughts, right? People can have a monopoly on what they write, people can have a monopoly on what they make, but we don't want people to have a monopoly on ideas because that would be very scary. We couldn't think of something that someone has a monopoly on, and then we'd have the thought police. And that would have also broader implications as to what you could do in coming up with your own stuff. And so under Section 5.1 of the Industrial Designs Act, you're told that the utilitarian characteristics of the product are not protected under the Act. And we'll see that's a distinction that's even more important under this regime. So basically, right, to make things simple, you need two things. You need a design that is original, that is not, utilitarian, but that is a design, and you need a product that is mass-produced, 50 or more. That's always the trigger issue. And, as we'll see, what are you granted? You're granted in a similar way as you are under all of the areas of intellectual property law that we're going to see, including copyright law, basically a monopoly for a limited period of time, right? So for copyright law, it's life of the author plus several decades. Well, in that case, it's 10 years. And so for 10 years, no one can take it, copy it. After that, they can do whatever they want with it. It's no longer yours, and they don't pay you for the right to use it. And the question arises from what I've just said as to what happens when, right, you're mixing the utilitarian characteristics. So as I said, under Section 2, you have the definition, and under Section 5.1, you have the exclusion that says that you cannot protect the utilitarian characteristic. And you have a case that's reproduced at page 288 of the textbook about clothes hangers. And what happens, right, is that these clothes hangers are not sold to the public, right? They're used by, say, people in warehouses. So that's kind of a good indication that they're not bought for their design, right? Typically, people in warehouses, as opposed to homes, don't really care about how this stuff looks. They buy it for its utilitarian function, right? They'll buy a hanger because they want a hanger, not because it looks good. And second, right, the court says, well, there's clothes on them, and so obviously the design is not important. It could be any hanger, and even if you make it look really good, it's not a design that is meant to, as we said, under Section 2, appeal to and be judged solely by the eye, because, namely, you don't see it, right? But then what happens if you have both, right? What if you have, let's say, a design, right, for making something? And it's kind of hard to be more specific. But let's say you have a design for making something that you're allowed to protect because it has characteristics that appeal to the eye and you meet the other criteria, right? It's mass-produced and so forth. Well, what if you're protecting utilitarian characteristics simultaneously? So what if you have the blueprints for making something, right? Well, then you protect them under the Act. What happens, right, is that no one can basically copy your design, and that generally means that no one can make something that's essentially the same as what you're making. But what happens if your design is the only way to make the thing, right? What happens if, even by changing the design to be without the scope of the Act, there's no way for someone else to make something similar? And therefore, let's say it's a fork. Well, you end up with a monopoly over the concept of a fork, but you did that by meeting the criteria under the Act, right? You did that by accident. You didn't come in and say, I want a monopoly over forks, because they would have said that's excluded under 5.1. You met the definition, but you ended up with a monopoly over forks. And what are we told in the Minetti case, which is abridged very, very briefly at page 288? You're told that's a big no-no. You cannot do that. And so the fact that you're indirectly protecting a utilitarian function is going to exclude you entirely from the Industrial Designs Act. And the court goes further and says, why is that? Well, it's because we have another regime for people who invent stuff, right, that no one can make, and that is this new invention that you want to be the only one sold, and that is patent law, which is another very interesting area of the law which we're going to look at shortly. The other thing you're told, right, is that you can have coexistence of industrial designs and trademark. And so you'll recall I stressed at the beginning, right, that you don't have a choice. That the Copyright Act says you can't protect something that's mass-produced under the Copyright Act. And so even though you'd fall under the definition, you have to seek protection under the Industrial Designs Act, or not at all, right? That's not the case for trademark law. And as we'll see, right, in the next section of this specific lecture, there is under trademark law protection for unregistered stuff. And that is when your thing, right, what makes your product different, right, let's say the packaging on your chocolate bar, when that is so well known, right, that it is clearly a reason why people recognize and buy your product. And so then it's not going to be a matter of someone, changing it enough not to trigger the protection. It's going to be a matter of making sure that no one makes something that's even remotely similar, because then they'd be defrauding you, essentially, as we'll see. Then they would be using your goodwill. And your goodwill is your reputation. People buy your chocolate bar, they recognize it that way, and they pay more money for that. And if someone were to take your packaging, right, A, they would confuse people, and B, they would basically take advantage of this great reputation that you've built around this packaging for the past 50 years, and that would be unfair. It would be tantamount really to fraud, right, to taking advantage of your stuff, of your reputation. And so, you're told that trademark and industrial designs can coexist, not simultaneously, right? But we'll see that one of the main elements for trademark protection is that you have to have acquired distinctiveness. So your chocolate bar packaging is to be so well known that people recognize it as different and buy your thing because it is different. Well, what can you do, right? How do these two regimes coexist, you ask? Well, when you come up with the idea of the packaging, right, it might not be a good idea to use the same example, but let's say you come up with the design for a fork, for instance, right? Well, then you can seek protection under the Industrial Designs Act. And then what's going to happen, you're going to have this lower protection period that's going to protect you for 5 or 10 years. And for that 5 or 10 years, you're going to be the only one that's going to be making that kind of fork. Well, guess what happens after that? What happens is people start to recognize your product as distinctive, right? Because you've been the only one selling your product for 10 years. And then you might be able to seek registration under trademark law. And in fact, to go further, right, the smart companies will specifically try to do that. Right? They'll specifically use industrial design protection to eventually get trademark protection, which is, for a lot of reasons, more valuable to these companies. So the company probably doesn't care about someone stealing the design for their fork or their iPad or whatever it is. What they do care about is eventually getting the nuclear bomb of trademark protection, and that's allowed under trademark law, specifically, right, under the jurisprudence of the federal court. The federal courts recognize that these things can coexist in that way, unlike other regimes that I've discussed. So, what does it mean for something to be original, right? Again, we're in sections 2 and 3, which define what it means to have an industrial design and to be original. And the court says it has to be new. How new? Well, hard to tell, but more new than copyright. Copyright doesn't have much of an originality requirement, right? Copyright is more concerned about it being new in terms of it not copying something. So not copying something that is either in the public domain or that is someone else's copyright. And as long as you're not doing these two things and respecting the other requirements that we saw, generally you're good. This is a somewhat higher requirement. So it doesn't have to be groundbreaking, but it has to be new, right? You have to come up with an idea that's different from what people have made before, and it has to originate with the designer. And, as we'll see, under Section 3, again, of the Industrial Designs Act, you have a further limitation, right, that says basically that you have to register your thing within 1 year of disclosure, right? So when do you have to register it? And again, Section 2 is the definition, Section 3 is originality, so you might want to look at both of them. So, under Section 6.3, what does it say? Well, it says that the minister shall refuse to register the design. Obviously, the minister doesn't spend their days approving registration, it really means the person the minister designates to run the register of industrial designs if the design is filed more than 1 year after the publication of the design. So that's very important. And that brings us closer to patent law, right? So you'll recall my example of me inventing this really nice snowmobile, and I'm the first person that comes up with a snowmobile. Why would I not want to start producing the snowmobile and make money, right? I've got this great invention, obviously people are going to buy it and I'm going to make a lot of money. The answer is because I don't want people to steal my stuff. If I start making this snowmobile, right, within days, someone's going to take it apart, some big company's going to take it apart, they're going to figure out how it's made, and they'll copy it. And then they'll make it for cheaper, they'll make it faster, and I'm going to go bankrupt. People are going to buy it from them because it's cheaper, and they can get to market faster in more places with more points of sale and so forth. And so in patent law, right, we have this bargain with the government. So you recall, right, these various ideas about copyright law being about this bargain, right? This balance between making sure that people have their legitimate commercial monopoly and people accessing stuff in the public domain. Well, there is this tension here once again. What does the government seek to do? The government wants people to invent things. And for the reason I just said, right, people may not invent things if they're afraid their thing is going to get stolen. And so what do we want people to do? We want people to disclose and sell their invention, because that's good for society. And what are we going to do in return? We're going to give them, again, a commercial monopoly. We've got 3 commercial monopolies thus far, right? We've got one under copyright, one under industrial design. I just said there's one under patent law as well. So the person is going to have the exclusive right to sell their invention for whatever period of time. But there's this tension, right? This tension between annihilating competition. You'll recall I told you that it's a nuclear bomb on this system, right? It's the opposite of everything we believe in, at least on paper, as a capitalistic society, right? We're giving one person a monopoly. Usually we want competition, we want prices to go down, and we think that's how innovation happens. And here we go against that principle and give someone a monopoly again so they can disclose their invention, and so they're incentivized to invent things in the first place. So there's this tension, again, between various values in society, and industrial design law is quite similar to that. And so, under Section 6, right, you can only get protection 1 year after it's disclosed, because it has to be original, it has to be new, right? And if you just, publish it on the internet, say, again, your design, not your product, you just publish it on the internet for everyone to see for a year, then obviously you're not really worried about people stealing your stuff, right? Because not only did you tell everybody, you also waited for 1 year. So if it's registered after 1 year, not valid. And why do we have that? To incentivize people to disclose. And again, we see this similar bargain, right? The government is going to say, I'm going to register it, I'm going to give you a commercial monopoly, and in return, you're going to show me your thing. And so you have to produce with the government registry to get your industrial design protection. You have to produce your plans, your design, whatever it is, right? And you're told that this phrase is interpreted somewhat restrictively, right? So you have the case of Dart Industries, and basically someone starts trying to market their thing, right? So they have this design for something they want to produce, and they go to various companies and they say, would you be interested in partnering with me to make this thing? And the companies, right, look at it, and the question is whether that was disclosure or not. And the court basically interprets this previous definition from the Ribbons case of 1961 from the Exchequer Court, which basically said that the production of the product based on the design is the disclosure. And so you can shove it around as long as you're not making it, it's not disclosure. And then the court in the case we're discussing says, well, no, because again, this is industrial design protection. It's not product protection. It's industrial design protection. And so therefore, what we're protecting is the design, and what matters is disclosure of the design. And when the guy went to various companies, right, and said, look at this, I want you to produce this with me, well, in that case, he was publicizing his design, and that was enough. And you might think that that is dumb, right? You might think that the person is legitimately going to assume that if they just show it to 5 people in the boardroom that it's confidential. And you might be right. But that's not what the law says, right? What the law says is you've got 1 year after that. And so it's not really like when you show it to people in the boardroom, then it's public, right? Because even after that happens, you've got 1 year to seek registration. And so presumably, right, you're not going to be surprised. And again, we can think about some broader issues that differentiate industrial design law and copyright law, which we've seen so far. And we can think about copyright is protecting, that's my hypothesis, again I might be wrong, copyright being meant, right, the underlying purpose being meant to protect artistic works. And we saw, right, that you have this section 28 right, this moral right to integrity of your work, which recognizes really that copyright law is about more than you making money with your stuff. That there's an artistic element to it, and to the extent that there's an artistic element to it, right, then you should be protected for the integrity of your art and not just for your art as a means of making money. And of course, as we saw, under copyright law, that's where most art is protected. Sculptures, right, paintings, various forms of art are protected under copyright. And there isn't really a competitive dynamic to that, right? There isn't really a marketplace you're infringing, right? You'll see, I told you a bunch of times, right, that the countervailing concern is people accessing your work. So people being able to read your work, copy your work, use it in their own work, right? And I never told you really that there was a countervailing concern of people taking your stuff and creating a competing product, right? Which is the opposite of what I just said. And the reason I didn't tell you that is because it doesn't really apply, right? Competition doesn't apply to books, right? Might apply to book selling, but it doesn't apply to books, right? When you come up with a great book, right, we don't want Walmart to make a similar book and start, you know, selling it for cheaper. That's not the nature of books, right? Books are art. You don't want competition to drive down the price. You don't want, you know, people to basically make a cheaper version of your story. That's not really a concern. And so we weren't really worried about long periods of protection, right? Life of the authors was several decades, which is a really long time, right? That means your grandkids can be making money with your song long after you're dead. That wasn't a concern. But here, we're concerned with something that is fundamentally used in the economy, that's used by companies that are competing against one another and making things. And that's arguably why we have a lower protection period, right? Because, you know, the nature of competition is you want companies to compete, right? And so if you had protection for, say, 100 years, right, that would be bad because you could come up with a really nice glass, right? But then you'd have a monopoly on glass, on that type of glass for, say, 100 years. And that wouldn't really match the pace of competition and innovation, right? We want people to, you know, come up with a better glass before 100 years while respecting your legitimate right to make some money, right? And that's why we have, I think, this lower protection period. And on that issue, the people who wrote the book agree with me. And again, that might be a recognition not just that we want competition, but also that we want competition because it's not as artistic, right? So obviously it has to be original. As we said in the definition, it has to be new. So there is an artistic element to it. After all, it's a design, right? You're designing something of value to people, and it has to appeal to the eye. So people have to like it, recognize it, buy it for that reason, right? Well, It's an artistic work, but not of the same nature as the one we're protecting under copyright, and arguably because it's this hybrid between an artistic work and an industrial work, an industrial design, right, which is kind of a combination of the two, then that might be why we have this lower protection period. And I would argue also, it's just me speculating, that that's why we have registration, right? Because, again, the assumption might be under copyright law that artists don't register their stuff. And so if you had this requirement, it would be unfair. Because if you're a painter, you're not a lawyer. And so you're not going to think, right, that you have to go to the government and register your thing. That's not even going to cross your mind. What you're doing is painting. But in the case of an industrial design, then presumably you're a company that has a bunch of contracts, that knows a bunch of lawyers, and that should think about registration. And in that context, right, it is fair to ask you to register your stuff. And we also get benefits from registration. Because as we said under copyright law, right, I told you under copyright infringement, you have to show copyright and infringement. And because there's no registry that we can just produce that says, hey, Phil's got this thing, right? You have to prove that you have a copyright. Because you do have a copyright by virtue of the statutory requirements, but that's not written anywhere. You have to show that in court, and then you have to show infringement. If someone wants to recover from you, they have to show infringement, right? Well, again, assuming it's fair, as I said, to have people register their industrial designs as opposed to their copyrights, well, then registration is probably a good thing because everyone knows who owns what, and more importantly, everyone knows what it is. Because, as I said, to get registration, you have to have disclosure. So to have registration, they're not just going to put your name on a design and say, you know, Phil came up with this really nice glass. There's going to be a picture of your design in there. Last point, right, is ownership. Who owns the industrial design? And again, well, obviously the person who invents it, right, the person who makes it. It's, after all, an artistic work, but, right, but as was the case in copyright law, and as is the case just about everywhere else in the law, if you have an employer, generally they'll own it. You'll recall that I did this very long-winded explanation of agency, right, of why you're responsible for what someone else does. And I gave you the example of the criminal law where I have a relationship with someone, and even though I'm not doing the infringing act, right, if we have a plan and then my co-murderer or my co-bank robber accidentally murders someone, we've both committed murder, or manslaughter in that case because it's not intentional, or you don't intend in the first place to commit a murder. Well, in that case, we're both responsible. We've both done the thing. And then I gave you the example of my kid. If my kid goes out and bites another kid and causes damage, I'm responsible, but I haven't done anything wrong. I'm responsible by virtue of my relationship to my kid because a kid is not an autonomous human being, right? He's a human being that should be watched depending upon his age, and therefore I bear some responsibility. The same is true of an employer, of any relationship where there is control. And again, it's true for intellectual property law as well, even in the context of industrial designs. And so my employer is paying me to make a design, right? I'm already compensated for giving them my ideas, right? That's why they pay me a salary. Typically, the contract is going to say, we own what you make. But that's not necessarily so, and it doesn't necessarily have to be that way. Because by virtue of the employment relationship, right, my employer is compensating me as a designer with a salary to come up with design. And what do they get in exchange, right? Besides having me in the office every day, well, they get industrial designs, because that's my job. And therefore, under Section 12, right, if you are the owner, then if the company employs you, then typically the company will be the owner. And we also have an interesting point in Section 13, which is made very briefly in the book, which is a consequence of registration. So registration is mandatory, right? As we said, what does the registry say, right? The registry says Phil owns this and this looks this way. So it has my name, it's the name of what I made up, right? And it has a copy of my design, right? Design for glass, and then there's this design for glass, right? Well, one of the aspects that's in the registries, I just said, is me, my name. And therefore, right, if I assign the right, it also has to be in the registry. Like copyright law, it's an economic right, and so I can do whatever I want with it. I can sell it to a company, I can assign it in part, in whole, for free, for money, for a period of time, forever, whatever it is. But pursuant to that registration requirement, right, the assignment has to be recorded in the industrial design registry. And so we'll have to change the name of the owner, and the thing has to be in writing. The assignment has to be in writing for it to be valid.